Hello, my name is Douglas Pinkham. I am a divorce and family law attorney in Orange County, California. Although we do assist in the filing for divorces anywhere in California. So if you're interested in filing for divorce and need assistance, we can help you with that. Just as a side note, if you're only interested in asking an attorney to help you do the initial filing of the divorce and serving the other party, we do that for a very affordable flat rate. Go ahead and give us a call and we'd be happy to help you with that. Our phone number is 714-730-0111. So you may be wondering why I'm looking over there, and here I'm doing two different kinds of videos. I'm doing one where I've got the forms up and visible, so some of you will be able to see the forms and some of you will not be able to see the forms as I go through them. For those of you that cannot see the forms, it may be a good idea right now for you to locate and print the forms that you need to file for divorce. You will absolutely need an FL 110. You will need an FL 100. If you have children with your spouse, you will need an FL 105. And there are local forms depending upon what county you are filing your divorce in. In Los Angeles, for example, there is a local form that you need for jurisdictional purposes to show that you are filing the divorce in the right jurisdiction. They also have that form in San Bernardino. In Orange County, there is a form called a family law notice related cases that you need, and that, for example, is an Orange County form 1120. All right, so I'm going to go to the first form, the FL 110. It is a summons, and I'm going to start discussing how to fill this out. Now, the whole purpose of this video is to teach you or to tell you how to file your divorce if you choose to do it on your own without the need for an attorney. Now keep in mind, if you do something wrong and you file it incorrectly, it is harder, it's always harder to undo your mistakes and redo it the right way than to just do it the right way the first time. Again, if you decide to ask an attorney to help you, give us a call. We have a very affordable flat rate to help you just file and serve the divorce. Okay, if you choose to do it on your own, though, here we go. So at the top of the summons, at the top of the FL 110, you will see where it says notice to respondent. So you're going to put your spouse's name in there. Those of you that can see the form can see that I'm doing Jane Doe is the wife of John Doe, and John Doe is filing the divorce. So Jane Doe's the respondent, so her name goes at the top under respondent. Then the next space is for the petitioner's name. That's where John's going to put his name. Then the next box there is for the case number. Obviously, we're filing a new case, so there's no case number yet. Nothing goes in that box. Then, down at the bottom in box number 1, name and address of the court. So this one is for Orange County. And we can put Superior Court of California, County of Orange. And the address there is 341 The City Drive, Orange. Oops, we need to fix that. Orange, California. If you're doing it in LA, you're going to want to put the LA. You're going to want to put Superior Court of California, County of LA. Oh, I've got that spelled wrong there. And if you're in Riverside, then, County of Riverside. And you can get those addresses for your local court online without any question, without any problem. Easy to find that. So go ahead and pause this if you've got to go find that address, and then come on back. And then under 2 below is your name, your address, And you don't need to name that twice. That's a software glitch. And then, of course, the phone number, your phone number at the bottom. You don't have to put anything down here on the bottom. Okay. Then you'll notice on the second page there's nothing to fill out, but you may want to take notice of the 4 automatic temporary restraining orders. They're very, very important. What that is about is that when you file for divorce and after you serve the other party, you two are both restricted from doing those 4 things. Number 1, neither of you may remove the minor children, if you have minor children, from the state of California without the written permission of the other party or an order from the court allowing you to do that. So that means even if you want to just cruise over to Vegas or Lake Havasu, that's Arizona. So you're going to have to get written permission from your spouse or an order from the court. If you get an email or a text message from your spouse, that would usually qualify. That would usually be good enough. You don't necessarily have to get a written order to allow you to do that. Number 2 restricts you both from cashing, borrowing against, canceling, transferring, disposing of, or changing the beneficiaries of any insurance or other coverage, including life, health, automobile insurance, disability insurance, held for the benefit of the parties or their minor children. So what that basically means is don't mess with any insurance policies, period. Don't change any insurance policies. Don't cancel them. Don't change the beneficiaries. Don't raise or lower don't anything. Don't mess with insurance policies until the divorce is final. Number 3, you are restrained from transferring, encumbering, hypothecating, concealing, or any way disposing of any property, real or personal, whether community, quasi-community, or separate property, without the written consent of the other party or an order from the court, except in the normal course of business or for the necessities of life. So what does that mean? That means you can't start selling property or transferring property to your friend or your cousin. Can't start giving things away. You can't start taking loans against, property. You can't go out and take a $5,000 loan against your car unless you need that money for the necessities of life, or unless you're in the normal business of selling cars. Another good example is you're not allowed to go start selling all your jewelry unless you were in the business of selling jewelry. And if you're, a jeweler, then of course you can continue selling jewelry because that's your business. And then number 4, you are restrained from creating a non-probate transfer or modifying a non-probate transfer in a manner that affects the disposition of property subject to the transfer without the written consent of the other party or an order of the court. Before revocation of a non-probate transfer can take effect or a right of survivorship to property can be eliminated, notice of the change must be filed and served on the other party. So, perfect example of this is a trust. If you have a trust with your spouse, you can't just cancel the trust. You've got to give notice. You've got to go to court and get a court order to do that, or a written agreement between the two of you to get that done. There are also other methods for transferring property via a non-probate vehicle. So no matter what that is, don't make any changes in that area also. If you need more information on that, contact an attorney before you make any mistakes. So those are the 4 automatic temporary restraining orders that go into effect upon the filing and service of the other party. Upon the filing, they take effect for you. So immediately, you're not allowed to start doing those things. Your spouse can't be held to those standards until you serve them, until they have notice, until they know that, until you serve them with that summons, they're not going to be held to those standards. All right, so now we're going to go on to the petition. the FL 100. At the very top, and this is going to be true for almost any pleading. At the top, it's going to be the same every time. You put your name under name and firm name. If you're filing it yourself, you don't have an attorney's firm name, so you're going to put your name there. Then you're going to put your address there. Again, that quirk, it's writing it twice. So you're going to put your address, the city, state, zip code, then your phone number. Down there where it says, a couple lines further down, it says attorney for. Go ahead and put your name in there again. Then it asks for the Superior Court of California County of, and then put the county that you're filing this in. If you file it in Orange, that's great. If you file it in Riverside, that's fine. And then, again, you're going to put the court's address there. And I'm going to fix that. Okay, and the court name. The branch name that you're filing in. If you file in downtown Los Angeles, you can put Central or you can put Hill Street. If you're filing in Orange County, it's Lamoureux Justice Center. If you're filing in San Bernardino, it could be a couple different local courts. Get the local court name. And then you're going to put under petitioner your name. Under respondent, your spouse's name, and then you're going to mark where it says petition for. So if you're filing for divorce, you're going to mark divorce of a marriage, divorce or dissolution of a marriage. If it's a dissolution of a domestic partnership, then you're going to mark that. If it's a legal separation of a marriage, you're going to mark legal separation of marriage. If it's legal separation from a domestic partnership, you're going to mark that. So it's real simple. So mark the box that applies. If you're just regular divorce, regular marriage, then it's you mark the dissolution of marriage boxes. If you have already filed and you're refiling this after you've made some changes, then you're going to mark the amended box there. If it's not an amended filing, if this is your first one, do not worry about that. Leave it blank. Then over on the right there, it asks for the case number. Go ahead and leave that blank because this is the initial filing. You don't have a case number yet. Okay? Then below those boxes, you'll see number 1, legal relationship. If you are married, mark the A box, we are married. If you are a domestic partnership, then you mark B. If the domestic partnership was established in California, and C, if your domestic partnership was established in a different state. Again, we're talking about, in this example, a standard divorce from a standard marriage. And you're going to mark A. We are married. Okay, so then the residential requirement. What that means is you're going to either mark the petitioner or the respondent or both. What that means is you cannot file for divorce unless you have lived in the state of California for at least 6 months and the county in which you are filing for at least 3 months. So if you, the petitioner, have those requirements met, mark your box, mark the petitioner, and that's fine. If you both have lived in the county for state for 6 months and the county that you're filing in for 3 months, you can mark both boxes. All right. Now, you're going to mark B if your domestic partnership was established in California. And the reason there's a different box is because you don't have to have a 6-month requirement for that. So that's a different box if that's the case. You're going to mark C if it's a same-sex marriage and you were married in California but currently live in a jurisdiction that does not recognize California legal divorces or marriages between same-sex partners. So say, for example, you I'm not going to venture a guess, but there are other states that do not recognize at this point, that still don't recognize the legal California marriage between same-sex partners. If that's the case, then you can still get divorced in California even if you live in, say, well, let's say another state. Then you can mark C. And then you want to put under petitioner lives in. I don't know whether Texas recognizes same-sex marriages from California or not, but let's say they do not, and let's say you both live in Texas. Then you would put Texas under petitioner and Texas under respondent. If you live in a different state, then mark the state where you live. But again, if this is a standard marriage, standard divorce between opposite sex couples, a couple, then you're going to be marking 2A petitioner, and then we're going to move on. Okay, so number 3, statistical information. It's real simple there. You put the date of marriage in there, and you put in, after that, you put in the date of separation. Then you want to count the amount of years and months and put those where they apply on the next line. If it was a domestic partnership, then you're going to mark the next box, B, and you're going to put the date of the domestic partnership and the date of separation, and again, the amount of years and months of that relationship. Number 4 is minor children. If you two have minor children together, then you're going to want to mark box B. If you don't have children together, then you're going to mark A. So in this example, we have Dolly Doe, a daughter of John and Jane Doe. So we're going to put the minor children, we're going to mark B. The minor children are, and then we're going to put Dolly Doe's name in there, her date of birth. She's 7 years old. Is she still 7? Yep, she would still be 7. And female, obviously. And that is the rest of this page. Then we're going to go to the top of page 2. Again, petitioner is you, respondent is your spouse. We do not need to put in a case number because we don't have one yet. Then under number 5, legal grounds. Standard, if this is a standard divorce, you're going to mark divorce due to irreconcilable differences. If it's a legal separation, then you mark the legal separation box and then irreconcilable differences. Okay, then if this were a nullity of marriage, then you could mark B, and it would be due to incest or bigamy. There's the only two for a void marriage. There's the only 2 examples. Then there's voidable marriages also. If you're going through a nullity, make sure you get a little bit of legal advice before you fill this out. But standard divorce would be A, and divorce and irreconcilable differences. Then we're going to go to if you have children, and in our example you do. So under 6, child custody and visitation, parenting time. Under A there, it asks for legal custody of children too. Now, if you guys are getting along in the slightest amount and you want to share custody of your child, then you're going to want to mark joint under legal custody and joint under physical custody. If you do not want shared custody for one reason or another, then you're going to want to mark the box for you. So the petitioner on those boxes. Under 6C, child visitation, you can put visitation to the respondent. You do not have to, but they have these other forms where you could mark a box and then use that form to discuss what kind of legal and physical custody that you want. Those are custodial forms. You don't have to use them, but if you want to, go ahead and pull one of those up and fill that one out also. to give the court a better idea of what you want for the custody and visitation of the other party. Okay, then the next box, don't have to mark anything there. It's just sort of a warning. If there's children, then there's going to be child support. Under 8, spousal or domestic partner support, if you are the lower wage earner or if you do not work, you're going to want to mark A and spousal support to you, the petitioner. And on B, you're going to want to mark B, and you're going to want to terminate spousal support to the respondent. The court won't actually do this at this time, but if you don't mark it, it's hard to ask for it later. And then if, let's say, for example, you don't want to anger your spouse on this initial filing, you can get rid of all those, and you could mark 8C, asking the court to reserve jurisdiction to determine spousal support later to you. And that's a good box. That's fine. That means you can go in later to ask for spousal support. If you are the larger wage earner, you may want to put in there under C and mark both boxes. Now, why would you mark a box for your spouse to pay you if you're the larger wage earner? Keep in mind that you want to fill this out without knowing what's going to happen in the future. Sounds crazy, but who knows what could happen in the future. You could step off a curb and get hit by a bus and not be able to work. At the same day, your spouse wins the lottery. If that were if that were to arise and those facts were to happen, then your spouse would be paying you spousal support. So that's just why you do that. And then number 8, excuse me, that was 8. Number 9 is separate property. So you always want to mark B, and then the box there that is in front of the following list. And then you want to use some standard language here. You want to put in there that you want to write in something, and I have some standard language. Let me pull up my standard language real quick. I have language that just simply says all property obtained before the marriage, comma, after separation, or during the marriage by way of inheritance or gift. So what that means is say, it's real simple. If you go into the marriage with, a car and it's already paid off, that car is yours. It was always yours. It's going to be yours. It's always going to be yours in the future. So property that you obtained before marriage. Hold on, something popped up on my screen. Okay. Also, during the marriage, if you acquired something via inheritance, your parents passed away or an uncle passed away and left you $100,000, that money is your separate property, and you get to keep that. Your spouse doesn't get any of that. So so that's what we're talking about here. Now, if you have a specific car that you own before marriage, or some, $1,500 bicycle, or a motorcycle, or some furniture that's, relatively valuable, or a retirement account, 401k or something, and you owned it before you got married, then you want to specifically name that in this section. So you could put 401k through, ABC Corp. You could put in your Cannondale bicycle. You could put in that real estate. If you own real estate before you got married, you definitely want to list that. Located at, 123 Main Street. Mission Viejo or whatever. And then you can put in that other standard language. And all property obtained Okay. Or by way of gift and inheritance. Then over on the right, where it says confirm to, put petitioner. Okay. So that is the first page, or excuse me, the second page of the petition. Then we're going to go on to the third page. Again, at the top, put petitioner's you. Respondent is your spouse. You don't need to list the case number. Now the box, the section 10 is community property. If you have absolutely no property that either of you acquired during the marriage, then you can mark A. But that is very, very rare. Keep in mind here, it's very important that many people say, oh, we're not fighting over any property. She knows she can keep what she's got, and I'm going to keep what I've got, and we're getting along fine, and that's fine. She's going to keep her 401k. I'm going to keep my IRA, and we're just going to go our separate ways. I'm going to keep my car. She's keeping her car. Here's the problem. That property is probably community property. And even though you guys aren't fighting over it, you have to get a court order that says that your car is your car and her car is her car. And if you don't mark B, the box to determine the rights for the community property, then it's always going to be both of your car, theoretically, in the law. So to make this clean, you need a court order, ultimately your judgment, that says that your car is yours, her car is hers, your IRA is yours, and her 401k is going to stay in her name. And she's going to keep it. So if you don't, let's say, for example, that 401k remains, your wife keeps her 401k for 20 years. Or worse yet, let's say that you kept your IRA for 20 years going, and 20 years from now, you've been divorced for forever, and she comes back and says, hey, I want my half of that IRA. And you say, whoa, we weren't fighting over that. You kept yours, I kept mine. And she says, yeah, but we didn't put it in the judgment, so there's no court order. That's half mine. I want it. So you want to list your property and so that there's a court order that says it's yours. It's very, very simple. So you want to mark B, and you want to mark as follows. And in that section, you want to list all of the property that you acquired together during your marriage. If there's any real estate that you've purchased, land, a building, commercial, residential, a home, a condo, whatever it is, absolutely list that in this section. You want to put in standard language like, let's see, I have some other language. I have standard language that I use, and you're welcome to use something like this. So instead of naming every single chair and that kind of stuff, I have standard language that I use, and I just doctor it up to fit the right client. I have the family home located at, and then you put the address, automobiles, boat, wave runners, motorcycles, airplane, art. I've only had a few clients that had airplanes. Art, furniture and furnishings, electronics, tools, 2 dogs, 2 cats, collectibles, bank accounts, retirement accounts, insurance policies, stock options, annuities, pensions, 401ks, IRAs, investments, businesses, including, and then you name the business, credit cards and other debts, jewelry, cash, and other additional property, the full extent of which has yet to be ascertained. So that's the kind of language I put in there. Now keep in mind, if you don't have 2 dogs, you're not going to write that. If you don't have 2 cats, you're not going to write that. If you don't have an airplane, obviously you're not going to write that. No motorcycles, leave that out. If you have no insurance policies or stock options or annuities, leave those out. But if it applies, write it in there. It's good standard language to give the other side notice as required in the law. Okay? So the next section is section 11. Okay, keep in mind, back on that section, if you don't give the other party notice of a 401k, then the court doesn't have the authority to cut it up. If you don't list it, the court doesn't have the authority to give it to you. So list it. Very simple. All right, going on to section 11, other requests. If you intend to ask the court to order the other side to pay for your attorney's fees, then you need to mark A and respondent, because you want the court to order the respondent to pay your attorney's fees. If you want your name restored to your maiden name, you may want to mark box B and then put your maiden name, your entire name, in that box. And in this one it was Jane Doe, Jane S. Doe, so you'd want to write the middle name there also, your entire name there. Now keep in mind, you do not have to mark that box now. This is one of the very few things that you don't have to mark now, but can still do later. In other words, if you're not sure if you want to change your name now, maybe you have children and you may want to keep the same name as your children, you don't have to mark that box now, but if you change your mind later, you can change your name later back. Okay, then keep in mind, everything you're putting on here, you are swearing under penalty of perjury under the laws of the state of California. The foregoing is true and correct, so you want to make sure this is correct. Then, where it says date, you're going to date it. You're going to write your name underneath, and then you're going to sign on the right. The line below says type or print. That's signature of the attorney for petitioner. You are welcome to also fill in those boxes and sign a second time on the right, because you are acting as your own attorney. Some clerks do not require that, so if you don't do it, it's still likely going to get filed. But you're probably better off by signing both lines and writing the information on the left on both lines. Okay, that is the summons. Now we're going to move on to the third form. You only need this form if you have children with your spouse. If you have children with your spouse, you're going to use this FL 105. All right. So at the top, just like every other pleading, your name, your address. Again, we're going to get rid of the second one. We are going to, and your name below, where it says attorney for, as you're representing yourself. Then again, the court information, still misspelled there. Okay, so the court's address and the court's name, you figured that out for your petition. Same information goes on this one. Then petitioner's you, respondent is your spouse. We're not dealing with this guardianship box because we're dealing with a divorce. So you're going to skip that. Box number 2, there's a little box there. It says my present address and present address of each child residing with me is confidential under Family Code Section 3429, as I have indicated in item number 3. Now, you're going to mark that box if you're trying to keep your address confidential. Perfect example is if you have a restraining order and you don't want your spouse to know where you're living, or if you are living in a shelter, say a women's shelter, then you are not allowed to disclose that address, and you would mark that box. For any other case, you are going to disclose the address because you have to. So under 3, there are, specify the number of kids. So in this case, we only have 1 kid. We're going to put a 1 in that box. Then we're going to put under child's name, Dolly Doe, place of birth, let's say Anaheim, California. And then the birth date, we put her birth date there. She's female. And then she has lived at this address since birth. If it's not since birth, then you need to put the month and year that you moved into this present address, of which you're going to write in there under address. And if there's a prior address, you need to give the child's residence for 5 years. So you need to go back 5 years and list all those addresses in these boxes and the dates to which you lived in that address or the child lived in those addresses here. On the right, you're going to want to put, you have to put where it says child lived with, and we're going to put John and Jane Doe. And then it asks for the address, and you can put same if it's the same address as to the left there. Then the relationship, well, that's mother and father. Okay, then we're going to go down to the next section. If by chance there's multiple children, then you're going to put the next child's name under in the next section where it asks for the next child. If all of the and then of course the date, place of birth, date of birth, and male or female. And then there's a little box right under that second child's name that says that if you mark that box, it says that the residential information below is the same as the child above. So you don't have to retype it if the children always lived in the same home. In this case, again, in my example, we only have one kidder. We only have Dolly Doe. So I don't have to mark any of those boxes. I'm not moving on. If there are additional residences in that 5-year period, and because there's only room here for 4 different residences. If you lived in 5 different residences or more in that 5-year period, then you're going to want to mark C at the bottom and continue the information on another sheet of paper. You can just use a simple blank sheet of paper to write the same information down that you put on those other addresses, and just at the top put attachment 3C as it says. If there are additional children, if you have more than 2 children, then you're going to need to mark D, and you're going to need to use this additional form. An FL 105A gives room for 3 more information on 3 or 4 more children. If you've got 7 children, you're going to need a second additional form. So use those as needed. Then we're going on to page 2 of the FL 105. At the top again, you're going to put the case name. This may confuse you. IRMO just stands for in re marriage of Doe. So you can put in re marriage of in your last name. Or if you have different last names, you're going to want to put the petitioner's last name versus the respondent's last name. In this case, you could also put Doe v. Doe. Again, no case number, so that case number on the right is blank. Okay. Next section, 4. Do you have information about or have you participated as a party or witness in some other capacity in another court case or custody or visitation proceeding in California or elsewhere concerning a child subject to this proceeding? So, if there is any other kind of court case that involves the children of your marriage, then you want to mark yes and put the information in that chart below. If there's no other cases pending that had anything to do with these kids, then you mark no and you move on to the next section. So for example, if there was another custody case, then you're going to want to mark that information in there. Then the next section, 5, a little hard to see it there, but if there was a domestic if there was a domestic violence case or restraining orders or protective orders with regard to these children, then you're going to need to mark box 5 and fill in that information in the chart below 5. If there's no restraining orders, don't need to mark that, and you move down further. 6. Do you know of any other person that is not a party to this proceeding who has physical custody or claims to have custody of or visitation rights with any child in this case? So, for example, if grandma would claim custodial rights, then you're going to want to mark yes and put grandma's information in there. That kind of thing. So if there's somebody else that would claim custody of this kid or custodial rights with this child, maybe, well, then you're going to want to mark that. Okay, then that's the end of the form. Then you're going to want to put the date at the bottom, write your name where it says type or print the name, then sign to the right. If you had other residences and you had an attachment 3C, if you had additional children, so you had that FL 105A form attached, then you're going to want to mark 7 and tell us how many pages you have attached to this. Okay, but if you don't have any additional pages, like ours did not require it, then you don't need any more. That completes the FL 105. And now I'm going to, so in many, many counties, those are the only forms you need to file your divorce if you have children. You need to check, though. Check with your local county and your local family law courthouse that you're going to file your divorce in, and ask if they have any local forms. I only have this next form as an example. This form is only needed in Orange County, but like I said at the beginning, there's many counties have local forms that you have to fill out too. So find out. I'm only using this form as an example for Orange County, California. This is a required form in Orange County. It's called a family law notice related cases. If you're in Riverside, ignore this form, you don't need it. If you're in San Diego, ignore this form, you don't need it. Even Los Angeles, you don't need this. Only Orange County. But if you're in Orange County, again, you're going to put your information at the top, like any other pleading. You're going to put your name and address, your phone number, and then in this case, you're going to mark Lamoureux, where the court's at, Lamoureux Justice Center. Then the petitioner is you again. Respondent is your spouse. You don't need a case number because we haven't filed anything yet. Then, under 1, you're going to put other names that you have used. Our John C. Doe is also known as John Charles Doe, and he also goes by Jack Doe. So we've written those names in there. Jane S. Doe does not have any other names, so no other names. Oh, actually, we do want to put in her maiden name. So Jane S. Smith, or whatever her maiden name was. You're going to need to put that in there. Okay, so number 3 is other cases involving either the party or children of this marriage. So if there is a restraining order, or if there's any other custody orders, or if there was some criminal matter with regard to you, your spouse, or your kids, that information needs to go in here. Okay, if there was, then you'd mark box 3. You'd put the party or the children's name who's involved in that case to the right, and then you put in the information necessary on the chart below. If there are no other cases pending that have anything to do with you, your spouse, or your children, then you're going to mark 4 that says there are no other court cases involving either party or the children of the party. Then again, date at the bottom, write your name below the date, and sign your name to the right. And that completes all of the forms that you would need to file in California for divorce and Orange County. Keep in mind, if you want help filling out these papers, we at Pinkham & Associates have a very affordable flat rate to help you fill out the paperwork, and we can help you fill it out anywhere in California and file it anywhere in California. We will also help you get your spouse served so that the time limit, so that the time starts, and we can get this rolling for you. If you have any other questions, you're more than welcome to give us a call at Pinkham & Associates. Again, our phone number is 714-730-0111. Again, my name is Douglas Pinkham, and I'm happy to have been able to help you out. Have a nice day.